HR slides a stack of papers across the desk on your first day and says, just standard onboarding stuff. Sign wherever it's flagged. You don't want to be the difficult one, not on day one. So you sign, you smile, you hand it back. 2 years later, you're sitting across from an employment lawyer. You've just been let go. You think you have a case. The lawyer looks up from the paperwork and says, I'm sorry. You signed an arbitration agreement on your first day. You waived your right to sue before you even had a login. That one signature, the one that felt awkward to question, cost you everything. And here's what you need to understand. That wasn't bad luck. That was the system working exactly as designed. There's a specific mechanism companies use to make sure you never slow down long enough to read what you're actually signing. It has a name. It runs through every document on this list. And by the end of this, you'll know exactly what that mechanism is, what triggers it, and what to say when each of these 7 documents gets put in front of you. Because this isn't an edge case. This happens to smart people, to people who do good work, to people who showed up, performed, and still found themselves sitting across from a lawyer hearing words they didn't expect. The only variable, the only one, was what they signed without reading. There's a name for what's happening in those moments. Call it the signature window, the brief, socially pressured gap between when a document is handed to you and when you're expected to return it signed. Companies don't engineer the signature window by accident. They engineer it because it works. The discomfort of pausing, the fear of seeming difficult, the sense that everyone else just signs this stuff without question. All of it is load-bearing. The system only functions if you keep moving. There are 7 specific documents that companies routinely hand employees inside that window. Each one transfers something from you to them: your legal rights, your career options, your future income. The transfer only works if you don't slow down. So let's go through all 7. You already know this meeting before I describe it. Your manager is uncomfortable. HR is uncomfortable. You're uncomfortable. Everyone wants it to be over. There's a form on the table, sometimes preloaded with language like I accept responsibility or I acknowledge that I've violated company policy, and there's a signature line at the bottom. The implicit message in the room is, sign this and we can all leave. Here's what that document actually is. Not a receipt, a record, a legally binding admission, in writing with your signature on it, that can be used to deny unemployment benefits, undermine a future wrongful termination claim, or justify the next disciplinary step in a process that may have already been decided before you walked in. This is the clean signature trap, the assumption that signing means agreeing, and that agreeing is the only available move. It isn't. What you write instead of a clean signature: receipt only, I disagree with the contents of this write-up and will be providing a written rebuttal. Then you write that rebuttal, 1 page, specific timestamps, actual email threads, documented communications, named witnesses where relevant, no emotional framing, just the factual sequence of events as you experienced it. If they won't allow you to annotate the form directly, then I'll submit my rebuttal by email for my personnel file. Send it immediately after the meeting to both HR and your direct manager. Subject line: rebuttal to disciplinary action. Date. Your version of events is now part of the official record. That matters, especially later. Here's where it gets interesting. The reason later matters more than most people expect right now is something we'll return to when we get to document 3, because documents 1 and 3 are designed to work together in sequence, and almost no one sees that connection until it's too late. This one shows up during onboarding, or it gets slipped into a policy update email 3 years into your tenure with a subject line that reads important: updated employee handbook, the kind of email most people skim and immediately file. HR will describe it as standard. It is not standard in the way they're implying. What an arbitration agreement actually does. It removes your right to take your employer to court. Any dispute, wrongful termination, wage theft, discrimination, harassment gets handled by a private arbitrator instead of a judge and jury. Closed-door process. No public record. Virtually no right to appeal. And the decision-maker is a professional who handles these cases regularly on behalf of companies for a living. You've done this once. They've done it hundreds of times. That asymmetry isn't incidental. It's the point. There's a name for this: the private forum shift. The moment you sign an arbitration agreement, the entire legal playing field moves from a public courtroom with established rules and procedures to a private room with a professional who, in many cases, has worked with your employer before. You just don't know that when you're signing, what you say when one is handed to you. I'll review this carefully and get back to you by specific date. Then ask directly whether there's an opt-out window. Many agreements include one, and companies do not volunteer that information. If they pressure you to sign, immediately sign it, but write directly beside your signature. Received under review, I do not agree to arbitration. That notation creates a contemporaneous record of your objection. Remember the story from the opening, sitting across from the employment lawyer, being told you'd signed away your right to sue on day one? This is that document. This is exactly how that happens. The next part is what most people never figure out. The arbitration agreement isn't just dangerous on its own. It's dangerous in combination with the document that sometimes arrives alongside it, buried inside a performance improvement plan, at precisely the moment when you have the least leverage and the most to lose. Performance improvement plans. Companies present these as a structured pathway to improvement. That framing is not always genuine. Here's what most people miss. Signing a PIP isn't always just confirming receipt. Read the signature line carefully. In many cases, signing means you're agreeing with the factual characterizations inside the document, the assessments of your performance, the alleged policy violations. You're not just acknowledging a piece of paper. You're producing a signed admission that can later be used to deny unemployment benefits or to undermine a wrongful termination claim. But there's a second layer, and this is the one that most people never see until after the fact. Think about the last time you heard about someone who received a PIP and was let go 30 days later. You probably thought, well, they didn't improve enough. That's the story companies tell. Here's the mechanism underneath it. Call it the paper trail protocol, the practice of issuing a PIP not as a genuine improvement tool, but as retrospective documentation for a termination decision that has already been made. The 30-day window isn't an opportunity. It's the structured creation of a paper trail demonstrating that the company followed due process. HR's legal exposure decreases. Yours increases. The PIP is precisely where those two lines cross. This is why the disciplinary write-up from document 1 matters so much. If you signed it without annotation, it becomes Exhibit A inside the PIP. If you submitted a rebuttal, that rebuttal sits alongside it. Same document, completely different legal context. That's the sequence almost no one sees coming. What you write instead of a clean signature, acknowledging receipt only. I disagree with the statements and conclusions contained herein, and will be providing a formal written rebuttal. Then write that rebuttal. Specific dates, quantified metrics, documented evidence. Note explicitly where promised training, tools, resources, or managerial support were not actually provided. No emotional language, just the record. You are not going to argue your way out of a PP during the meeting itself. What you're doing is ensuring that if this document is ever used against you, in an unemployment hearing, in an arbitration proceeding, there is a detailed counter record already filed directly alongside it. Speaking of documents designed to eliminate your options right before you need them most, the next one doesn't even present itself as a legal document. It presents itself as someone doing you a personal favor. This one doesn't arrive as a form. It arrives as a conversation that sounds like genuine concern. A manager pulls you aside. Look, I'm trying to help you here. If you resign, it'll look so much better on your record. We can part ways professionally. I just want what's best for you going forward. That framing is constructed carefully. What they actually want is for you to quit voluntarily, because the moment you sign a resignation document, you almost certainly lose eligibility for unemployment benefits, and you hand the company a clean legal defense against any wrongful termination claim. You quit. They didn't fire you. Case closed. Their legal exposure disappears. You absorb all of it. This is the graceful exit offer, and it is one of the most effective document-based transfers in this entire list because it packages a precise legal maneuver as an act of personal kindness. You feel like you're being given a choice. You are not being given a choice. You're being offered the opportunity to absorb all of the legal and financial consequences of a decision the company has already made, while they retain none of them. It sounds like generosity. It is not generosity. Your response when you find yourself in that conversation: if the company is ending my employment, I need that documented in writing. I will not be resigning. Then stop talking. Don't argue. Don't fill the silence. Don't let it become emotional. Immediately after that meeting, send a documented email to HR. To confirm, manager's name asked me to resign today. I declined. If my employment is being terminated, please provide written documentation of that decision. Timestamped, specific, on record. The conversation they were hoping would quietly disappear is now documented with a time and a name. Here's where it gets interesting. The next two documents don't arrive when you're being pushed out. They arrive when you're starting fresh or somewhere in the middle of things, when you have no particular reason to be on guard, which is precisely when they're most effective, because the signature window doesn't only open under pressure. Sometimes it opens when everything feels fine. A non-compete says you can't work for a competitor within a defined window after you leave. A non-solicitation says you can't reach out to former clients or colleagues to bring them with you. On the surface, both sound like reasonable protections for legitimate business interests. The problem is never the concept. It's always the language. Phrases like any business similar to ours or any client the company has ever had contact with are deliberately broad. What reads like a narrow, reasonable restriction during an otherwise celebratory onboarding week can, in practice, prevent you from working in your own professional field for a year or more after you leave. Not a niche carve-out, your entire career lane. This is the scope creep clause, language that sounds specific but is written to be as expansive as possible in enforcement. The company's legal team drafted it that way. You're reading it for the first time under social pressure on a Tuesday morning. What you ask before signing: can you define specifically what companies would fall under the competitor definition? And can you define what constitutes a client contact for the purposes of non-solicitation? If they can't or won't answer those questions in writing, that tells you something important about how they intend to use the document. Enforceability varies significantly by state and country. In California, for example, non-competes are largely unenforceable. In other jurisdictions, courts routinely uphold them. That variability isn't your protection. It's a reason to know exactly what you're signing before you assume you'll be fine. Narrow the scope in writing before you sign it, not after. After is too late. You've just been let go. There's a check on the table, and attached to that check is a document asking you to waive every legal claim you might have against the company, past, present, and in some cases future, in exchange for a severance payment. The check is real. The rights you're surrendering are also real. This is the exit package illusion, the framing of a legal release as a routine administrative step, a formality, something everyone signs. It is not a formality. It is a contract in which you agree, in exchange for money, that the company did nothing wrong and that you will never claim otherwise. What most people don't know, you typically have 21 days to review a separation agreement. If you're over 40, the Age Discrimination in Employment Act mandates 21 days minimum, plus a 7-day revocation window after signing. Companies are not always forthcoming about that timeline. The implicit pressure, the unstated suggestion that the offer might disappear if you don't sign now, is part of the mechanism. What you say, "I'd like to review this with an employment attorney before signing." That's it. That's the whole sentence. You don't need to justify it further. Then you actually do that. Because what looks like a standard severance offer occasionally contains non-disparagement language so broad it prevents you from discussing your own employment history, or clawback provisions that allow the company to reclaim the severance under circumstances that are conveniently undefined. The severance payment is real. What you're giving up in exchange for it may be worth considerably more. This one is almost always buried in onboarding. It arrives with the benefits forms, the direct deposit setup, the parking pass instructions. Nobody flags it as significant. It doesn't feel significant. Here's what it does. In its broadest form, it assigns ownership of anything you create during your employment and sometimes for a period after to the company. Not just what you build at work on company time using company resources. In some versions, anything you create, the side project you've been developing for 2 years, the tool you built at home on weekends, the framework you designed before you ever heard of this company. This is the creation transfer clause. And it is the document on this list that generates the most genuine surprise because the consequences tend to surface not during a termination, but at the exact moment something you created becomes valuable. You announce a launch, you seek funding, you file a patent, and the company surfaces an assignment agreement you signed 4 years ago on your first Tuesday. What you do before signing. Read the scope definition carefully. Many jurisdictions require that invention assignment agreements include explicit carve-outs for work created entirely on your own time without company resources, unrelated to the company's business. If your agreement doesn't include that carve-out explicitly, ask for it in writing before you sign. Many companies will agree to add it. They just won't offer it unprompted. If you have existing projects, prior inventions, or ongoing creative work at the time of signing, list them on the agreement as excluded. Most agreements have a space for this. Use it. The list you make on day one is the boundary that holds later. So here's what connects all 7 of these documents. None of them are secrets. They're not hidden in the fine print of something you'd never encounter. They're handed to you directly by a person sitting across from you at a moment specifically chosen because you have the least possible reason or the least possible leverage to slow down and read them carefully. That's not carelessness on the company's part. That's architecture. The signature window is real. It's engineered. And it works because of a specific social mechanism. The assumption that slowing down makes you look difficult, inexperienced, or suspicious. The assumption that everyone else just signs this stuff. That it would be embarrassing to ask. That it's probably fine. It is not always fine. Every document on this list is a transfer. Rights, options, income, legal standing, moving from you to the company in exchange for nothing except the relief of not having an awkward conversation on a day you wanted to make a good impression. The countermove isn't paranoia. It isn't adversarial. It's a single, consistent behavior. Read what you sign. Take the time you're legally entitled to take. Ask the questions that make people uncomfortable, because the companies that designed these documents were not uncomfortable when they drafted them. They were thorough. The least you can do is be equally thorough when you sign them. If this channel is useful to you, it's because understanding how organizations actually work, not how they say they work, changes what you're able to do inside them. That's the whole point. The next time HR slides a stack of papers across a desk and says just standard stuff, you'll know exactly how standard it is.